No, so, are you staying here?
Court rise. Appeal in the matter of London Borough, Rowe and London Borough of Haringey.
Yes.
My Lords, I appear for the appellants, along with Miss McGibbon and my learned friends, Mr. Grundy and Miss Moat, appear for the respondents.
Yes. Now, before you proceed, there's one preliminary matter we ought to deal with. Well, two, in fact. The first one is easy. I see from what's on the bench that you got the message about the legislative history, because I do think we all think we need to have a look at that. So I'm pleased that you got that message. Secondly, the question has been raised as to whether this appeal is academic, which we have also turned our minds to. Our provisional view, and I emphasise the word provisional, is that the appeal is not academic for this reason, that although the council has agreed to withdraw the review decision which was under attack, nevertheless, the issues of law that arise on the appeal are ones that still divide the parties and will simply reoccur on any subsequent decision and therefore still require to be decided. And so in those circumstances, we are minded to proceed to hear the appeal, but obviously if Mr. Grundy wishes to try to persuade us otherwise, then we will hear what he has to say.
My Lord, I don't.
Thank you. So, Mr. Van Heegen, over to you to open your appeal.
So, my Lord should have the core bundle and the supplementary bundle.
Yes.
And then there's the main authorities bundle, and then, as my Lord just indicated, there's this further authorities bundle. And there's an additional document as well, which is Chapter 6 of the Code, which the respondents haven't agreed can go into the supplemental authorities. So that's sort of additional to the supplemental authorities. And the reason we wish to rely on that will become clear when we look at ground 3, but it contains a definition of what's reasonable to continue to occupy. So we consider it to be important for the court's consideration.
All right, well, we'll deal with that when we come to it.
There are 3 grounds of appeal, and I'm going to deal with them in this order. The first relates to the application of the statutory test for overcrowding. And the issue there is whether it relates to the room occupied by the appellant or the shared house generally in which the room is situated.
Yes, there may be an alternative answer as well, which is not one contended for or by either party, which may become a little clearer when we look at the statutory history.
Very well. And then the second ground relates to whether that test was properly applied in this case and whether the issues of overcrowding were properly assessed. And then the third ground is rather different. It's about the relationship between reasonable to continue to occupy and suitability.
Yes.
So if I can turn to the first ground first, and the starting point in my submission is the review decision, which sets out, this is in the core bundle, page 105.
Yep.
It's paragraph 11, it sets out the relevant facts for the purposes of grounds 1 and 2. So it's a shared house, and the appellant has a room in that shared house, which she occupies with her 2 sons, and at that time they were 7 and 4. And what's said in paragraph 11 going into paragraph 12 is that the reviewer has considered the overcrowding provisions. It said the space standard, but it may be that the reviewer is actually looking at the room standard, and found that in relation to that room, the room that's occupied, there's no overcrowding. And that's dealt with in the judgment below at page 56, also the core bundle. It's paragraph 75 of the judgment. Paragraph 75 starts to talk about Section 3 of the Housing Act 88, because that's the reason for the decision. Then the decision is on about line 6. Therefore, I find that the dwelling, for the purposes of Section 325 of the 85 Act, is the appellant's accommodation, not the entire property. The appellant's accommodation is the room. And in my submission, that decision is wrong, and that overcrowding should have been judged by reference to the entirety of the shared house, not just the room.
Yeah.
There is a definition of the dwelling for these purposes, and it is contained in the authorities bundle, the main authorities bundle, at page 14.
How many?
14.
Thank you. Do you have tab numbers?
Yes.
Tab 2.
Tab 2, exactly. It's right at the end of tab 2. It's section 343. And it's the second definition. Dwelling means premises used or suitable for use as a separate dwelling. So, in my submission, there are really 3 constituent parts. It has to be a dwelling, has to be a separate dwelling, and it has to be either used as a separate dwelling or suitable for use as a separate dwelling. If one turns to page 5 of the authorities bundle, one finds section 324, which contains the definition of overcrowding. And there are 2 different standards for approaching the issue of overcrowding. The first is the room standard, 324A, and the second is the space standard. And a dwelling is overcrowded when the number of people sleeping in the dwelling contravenes either or both of those standards. Turning over to page 6 is section 325. This is the room standard. This is the easy one. And subsection 1 says that the room standard is contravened when the number of persons sleeping in the dwelling and the number of rooms available means that 2 persons of opposite sex who are not living together must share the same room. And we can see from 2A that children under the age of 10 are left out of account So for the purpose of the room standard, we ignore the fact that the appellant has 2 children, 2 boys. So we're really just looking at the appellant, and obviously she doesn't share with someone who she's not living together with, if one looks at the room standard. The room standard, subsection 1 that we just looked at, refers to dwelling and the number of rooms. Prima facie in my submission, what these standards are aimed at is looking at a number of rooms rather than just an individual room. If one turns over to page 7, one finds 326, which is the space standard. And again, in subsection 1, the concentration is on the floor area of the rooms of the dwelling. So again, prima facie looking at multiple rooms rather than a single room in the dwelling. What one has to do here is look at table 1, look at table 2, and find out which one gives the least number of people. So in table 1, one looks at the number of rooms in the dwelling, and then look across the right-hand column, number of persons who are allowed, given the number of rooms. But table 2 contains restrictions in relation to that, because depending on the size of the room, the number of persons who can occupy that room may be limited.
And yes, you emphasise the expression number of rooms, but we can see from table 1, you can have 1 room.
Exactly, you can have 1 room, yes.
So do the references to number of rooms really help you that much?
Probably not, but I say that if it's not a 1-room dwelling, then one's looking at numbers of rooms.
And under the 85 Act, Part 10, which dealt with overcrowding, went from section 324 to 344. Is that right? And so section 343, the definition of dwelling, which you took us to, was in this part. So
yes.
That's part 10.
Exactly, of the 85 Act, yes.
Thank you.
Well, while we're looking at the current statute, now might be a good idea just to go back and look at the historical position.
Yep.
So that's the Index of Supplemental Authorities.
Just before you leave,
Yes.
326. How many rooms do you say there were in this dwelling?
We don't know.
So
We do, don't we? Aren't there 4 other lettings? Oh, if that's the right word.
We know there are 4 other adults, and I think we know that one of them's a female, but we don't know how many rooms there are.
What, in the sense that one of the adults might have had more than 1 room, or what?
We simply don't know how many rooms there are. Well, we know the appellant has a room. We know there are 4 other people there, but we don't know if they have a room each, or there are 2 further rooms or 3 further rooms. We just don't know. So we can't work out, this is really our ground too, but we can't work out whether there's statutory overcrowding because we don't have the information.
thank you.
So looking at the historical position in the supplementary authorities, the starting point is the 35 Act. I just invite my lords just to read section 2 of the 35 Act, which is on page 2 of the supplementary authorities, and that seems to be the first time one gets a definition of overcrowding. So the first time one sets out standards in relation to overcrowding.
So the expression here is dwelling house.
Yes, but there's a definition, if my lord turns to page 5, which is very similar, if not the same as the current one. So used as a separate dwelling, or suitable for use as a separate dwelling, but obviously phrased slightly differently.
So your submission is that sections 2 and 3 are the predecessor sections to the Part 10 sections that you've taken us to.
Yes. So this section that we're looking at now, sections 2 and 12, they seem to be the first time that this concept appears. And I'll stand corrected on that, but the research that we were able to carry out yesterday seems to indicate this is the first time. Section 3 sets out an offence. And then if one looks at page 6, one gets the space standard tables.
And the difference, or a difference, is that where section 324 and following deal with a dwelling, section 3, the language is dwelling house.
Yes.
And that, would I be right in, I haven't gone back this far, but we've gone back to the 1957 Act, and in the 1957 Act, the use of dwelling house is ubiquitous, rather in the same way as the use of the word dwelling is ubiquitous in Part 10 of the 1985 Act.
Yes. We're going to look now at the 57 Act. We're going to look now at the 57 Act.
Just looking at the table in the 35 Act, that looks as if the room standards and space standards haven't changed at all since 1935. Is that right?
Yeah, I was just doing the compare and
Sorry,
contrast.
that is right, yes. It seems that we haven't changed our standards in relation to overcrowding since 1935.
Thank you.
The only difference I can see is in relation to table 2, where the room size is between 70 and 90 square feet.
It looks as if it might be a misprint. It says we're half, but it must be 1.
So that's the 35 Act, and then the 57 Act. So section 77 is in very similar terms to section 2 that we've just seen. It's on page 7. Page 8 contains the offence, and the definition is on page 10, section 87. And it's the same. Of course, my Lord's point's a good one, that the words dwelling house have now been replaced by the word dwelling in the 85 Act, but the definition is basically the same.
Can I just ask, out of ignorance, that whatever the size of your property, whatever the size of the rooms, under these standards, you can't have more than 2 people in the same room. Is that right?
Yes, that's correct. Under the space standard, that's correct.
But there must be many properties in the country which fall foul of that standard. Is this one of these statutory provisions which is just regularly not complied with?
Well, obviously you can have children,
Yes.
but you can't have adults. You can't have more than 2 adults.
You can't have more than, 2 children counts as a person. Anyway, it doesn't matter for purposes of appeal, but maybe the local authority knows, but is there something which is...
So I don't know if I can say Section 1 of the 35 Act, Section 76 of the 57 Act, and similar provision in the 85 Act put a duty on local authorities to every now and then carry out an inspection for the purposes of overcrowding.
And what are the results?
Well,
Maybe you don't know.
no, I don't know the results, but I'm not. I do a lot of work for local authorities, and I have never come across an inspection in relation to overcrowding across a local authorities district. And also, I haven't ever come across a criminal charges in relation to overcrowding.
Okay, thank you.
But my lord's right, you could either have 2 adults or you can have an adult and 2 children, as in this case, but you can't have any more than that.
Or 4 children, if they're all under
Yes.
10.
Yes.
Yeah, thank you.
And the other document in this is the Law Commission report. And the only really relevant bit is on page 9 of that report. And the debate was whether to remove the phrase working classes from the definition. And the conclusion was to remove that from the definition because essentially it was said that it didn't add anything because it was mainly working class accommodation that was overcrowded. And my low friend's indicating that page 22 there's another reference.
So the 57 Act was not to apply retrospectively in relation to houses that were already overcrowded, only in respect of houses that became overcrowded after the 57 Act came into force. And they said, and the Law Commission said effectively, we can't imagine that there's anybody still occupying there's anybody who was a pre-57 occupant in 1985 when the 85 Act came into force. So we'll remove the lack of retrospectivity.
So it seems to be existing overcrowding in 1935.
Yeah.
Yes.
So that's the historical position. And if I could go back to the main authorities bundle now and look at the cases of mainly Eurotemp and then very briefly CN.
Well, are you going to look at any other statutory provisions? Because there are other provisions which are potentially relevant.
I'm going to look at the provisions that are in the authorities bundle. I'm not going to look at any provisions which aren't in the authorities bundle. If my lord wants me to look at statutory provisions, I'm happy to do so.
You've looked at one line of provisions about overcrowding.
Yes.
What you haven't done is to take into account what was section 90 of the 1957 Act, which was dealt with overcrowding in houses dealt let in lodgings.
Yes.
And that line of statutory authority.
So we do have section 90 in the supplemental bundle.
Yeah.
So
Shall we have a quick look at that?
We can look at it now. It's my lord's right, I wasn't intending to look at it.
Well, the only reason I would be grateful for your assistance, because it seems to me that it's at least potentially relevant as it were as a second line of authority, and it ends up in the 2004 Act, or that line of authority ends up in the 2004 Act by a route which goes section 90 of the Housing Act 57, section 146 of the Housing Act 1980, section 358 of the Housing Act 1985, and then into part 2 of the Housing Act 2004. And if overcrowding in houses letting in lodgings is relevant, because this is a house in multiple occupation, then my present and provisional view is that the fact that those two lines of statutory authority sit alongside each other as the acts go through from 1935 to 57 and so on is potentially relevant to the interpretation of the sections upon which you rely.
Well, I can't address my lords on that now because I haven't followed that through.
Right. Well,
but we do have section 90 of the 57 Act, which is where it starts.
Yeah.
I'm not sure whether there's an equivalent provision in the 1935 Act. It may not matter.
No.
But shall we have a look and see what section 90 says? It's on page 11 in the supplemental.
I'm told by my junior there's no equivalent provision of this in the 35 Act. So
Right. Okay.
It's the start in the 57 Act.
Thank you.
Yeah, I can't take this any further at the moment because I haven't looked at those other provisions. So I don't.
Would it help if I just repeated the references which I think might be relevant?
Yes, and we'll look at the vote of the lunch.
No undertakings being given. Section 90 of the Housing Act 57. Section 146 of the Housing Act 1980, which substituted a new section 90, which is similar but not identical. Then section 358 of the Housing Act 1985, which forms part of a group of sections which are all abolished by or repealed by the Part 2 or by the 2004 Act. And then you've got the regime for HMOs in Part 2 of the Housing Act 2004. And the sections which are repealed by the Housing Act 2004 include sections 345 to 400, so therefore include 358.
I'm grateful for that.
Whether that all adds up to a row of beans, I have no idea. But
well, we will find out over the lunch.
Thank you.
So if I could go back.
Would it be convenient to look at the 2004 Act before we get into the authorities, or do you want to do that later?
I want to do that later if I may.
All right.
So I want to look at Eurotemp and then very briefly CN for the definition of what is a dwelling and a separate dwelling, because that seems to be the key to what is meant by dwelling for the purposes of overcrowding.
Okay.
So Eurotemp is in the main authorities bundle at tab 13, and we start at page 97. And one can see from paragraph 2 that the case is about dwelling house let as a separate dwelling. And from line 4, the key issue is whether the room which Mr. Collins occupied in the Viscount Hotel could qualify as a dwelling only if cooking facilities were there available. Turning over the page to 96, we've got paragraph 8. Start of paragraph 8 refers to a number of authorities, and then between G and H sets out the test, which is whether facilities are shared, and if it's a living room, a bedroom and a kitchen, then it wasn't a separate dwelling. But if the sharing was of a bathroom and a lavatory, then that didn't prevent it from being a separate dwelling. And in this case, if one looks at paragraph 9, going over the page to the top of 99, it said that Mr. Collins did not enjoy any space or facilities in common with other occupants. So it's factually distinct from the current cases.
The issue in this case was whether it mattered that he didn't have any cooking facilities in his room. All he had was a sandwich toaster and one or two other things.
Exactly.
Because some of the dicta in previous cases had said that kitchens were essential living space.
Yes.
And the House of Lords says, no, that's not the point. The point is, where do you live? And he lived in his room, and that was that.
Exactly.
But if you have use of a kitchen, then that's one of your living rooms. So if you have a shared use of a kitchen, you haven't got a separate dwelling.
Exactly. Yep. And that's why I rely on that on this case. So on page 102, paragraph 23, it's exactly as my lord describes it. So he's got a bed and a separate lavatory and a shower and wash basin, but he doesn't have cooking facilities because breakfast's available in the restaurant. And then at page 103, paragraph 30, we get the definition of a dwelling, which essentially is where one lives and makes one's home.
Apparently we construe it by reference to the Book of Common Prayer and the Mikado.
Yes.
Oh, and Paradise Lost as well.
And guilt and so on.
Yeah, that's the Mikado.
But these are indicative. They're not a definition as such. It's just saying this is the normal English meaning of dwelling or dwelling house.
Yes. I mean, essentially what he's saying is if it's your home, it's a dwelling. And then what this case does is then draw a distinction between dwelling and separate dwelling, as my lord said, and it all depends on whether you share living accommodation. And we see that on page 108, so it's paragraph 47. 7, right at the bottom at letter H.
Sorry, which paragraph?
47.
Thank you.
That's the end of that. It's about the last 6 lines. Depends on what you're sharing.
So some kitchens are living rooms and some aren't.
Yeah, exactly.
What about this one? Our case.
Yeah, again, we don't know. And that feeds into ground 2.
Well, do you have instructions as to how big the kitchen is, what use is made of it?
I don't. I can try and obtain those. But our point is quite simply that's irrelevant for the purposes of this appeal, because the respondents are not saying we judged overcrowding by reference to your room because you don't share the kitchen, we don't regard the kitchen as living accommodation. That's not the reason for their decision.
No, but it is significant because we're trying to identify, for the purposes of statutory overcrowding, what on the facts of this case is the relevant dwelling. Is it your case or not that the room in which your client lives, undoubtedly the bedroom, is her dwelling or not?
So what I'm being told is she does say she uses the kitchen, and we can look at that evidence later. But to answer my Lord's point, we say the question here is it a separate dwelling? And we say it is not a separate dwelling.
And that's because she uses the kitchen.
Exactly. And there is no
Therefore,
evidence.
it must be your case that her use of the kitchen falls on the side of a line that Lord Millett in paragraph 47 draws between a kitchen which is a living room, somewhere where you spend part of your time to live, and a kitchen where you just have use of the facilities.
Yes.
You can just go in and fill up a kettle or
Yes.
whatever.
Yes. But it's important to look at the context, because it's not our assertion, it's the respondent's case that the room.
Well, you say it's not your assertion, but your entire case is premised on the fact that the bedroom is
Yes.
not the dwelling.
It's not a separate dwelling.
It's not a separate dwelling.
Yes.
You have to make that good, because if the bedroom were a separate dwelling, you would apply the overcrowding standard to that separate dwelling, wouldn't you?
Yes, I agree with that.
So your case is she has use of a kitchen as well as her bedroom. That means the bedroom is not a separate dwelling.
Yes.
Right. You then go on to say that means the house as a whole must be a separate dwelling. Is that right?
It's not being used as a separate dwelling, but it's suitable for use as a separate dwelling. But at the moment, it's not a separate dwelling because of the shared use of the facilities, including the kitchen.
So your case comes down to the word suitable for use.
Exactly. It is not being used as a separate dwelling, but it is suitable for use as a separate dwelling.
But it isn't, because it's been broken up into separate accommodations
Yes.
that are used in multiple occupation.
Yes, but if only one family was, if the appellant was in there alone, then she wouldn't be sharing the kitchen with anyone else. So it could be used as a separate dwelling.
But this, surely these issues have to be resolved on the basis of reality, not on what would have been the position if something was different.
Well, whether it's overcrowded, yes, on the basis of the reality. Whether it comes within the definition of a separate dwelling, the definition includes a hypothetical situation. If it's not being used as a dwelling, is it suitable for use as a dwelling?
But it is being used as a dwelling. It's being used as several dwellings. They're not separate because they all share a kitchen, but it's got, we don't know how many separate households, but there are 4 other adults in the property. That may be 4 other households. It may be 1 other household. We don't know, but what we do know is that everybody uses the kitchen, so nobody has a separate dwelling, but it is being used as a place where a number of people, separate households live. It's a house in multiple occupation.
Yes.
So why do you say it's suitable for use as a separate dwelling when it's got all these separate households living in it?
It's not at the moment, but it could be used as a separate dwelling.
Is that what you say suitable for use as? It means could be used as
Yes.
if it was empty.
No, if it was occupied by one household, so there's no sharing.
Well, no, if it was occupied by one household, it would be let as a separate dwelling.
Yes.
But your case is you ignore the people who are actually living there and the physical arrangement which is actually provided. As a house, you could let it to a single household.
Yes.
Therefore, that becomes the test.
Yeah, when looking at what is the separate dwelling, the shared house could be a separate dwelling because you could let it to one household. It's not in fact being let as one household, which is why it's not actually a separate dwelling at the moment, but you could have it as a separate dwelling.
But only if you got rid of everybody else
Yeah.
that was living there.
Oh, absolutely, yes. But the definition is it being used as a separate dwelling, or is it suitable for use as a separate dwelling? Yes, it is suitable for use as a separate dwelling, but it's not being used as a separate dwelling at the moment because you'd have to get rid of the other people.
Speaking for myself, that seems quite an odd intention to ascribe to Parliament. I can understand if you've got an empty house, it's not actually being used as a separate dwelling because it's not being used at all. But you can quite sensibly say it's an empty house which is suitable for letting to a single household and so on. But if you've got other people, other households living in it, in what sense is it suitable for use as a separate dwelling? Only by hypothesising that everybody is removed and you start again. But that seems a very, very odd way of looking at the question. What we're looking at is whether there are too many people in the house.
We're looking at two things. We're looking at are there too many people in the house? That's the overcrowding question. But at the moment, we're looking at the house. What is the house? Whether it's the room or the whole thing. And in my submission, it's the whole thing, because the whole thing could be a separate dwelling.
Okay. Well, I think I do now understand your case. That the bedroom is not a separate dwelling because of the right to use the kitchen. The house is not a separate dwelling because it's let to a number of separate households. But the house is suitable for use as a separate dwelling.
Exactly.
Could you ever have a house, however, on your submission, could you ever have a house which has the necessary facilities, so it's got washing, it's got cooking facilities, no matter how many other rooms, could you ever have a house which isn't suitable for letting as a separate dwelling on your submission?
I can't think of an example off the top of my head. I'd have to think about it, but I can't think, because you could just clear everyone out and you can put one household in there.
Exactly. So it would mean that these provisions would always apply. That seems a bit odd to me, speaking entirely for myself.
They would always apply to a separate dwelling, yes.
But then you might say they're intended to, so as to ensure that the overcrowding provisions always apply.
Exactly. Because that's the whole point of overcrowding, is once you start putting multiple households into the same separate dwelling, the overcrowding provisions kick in. Can I just...
Any more in your attempt?
Yeah, I'm just going to finish your attempt. Can I just ask my lords to look on page 112, paragraph 58? I just invite you just to read that.
Can you enlighten me? How does one decide whether a kitchen is a living room in the sense that it's possible to occupy it and not merely cook and wash up in it? Does that depend on whether there's a chair in the kitchen? What does it mean?
It's going to be a question of facts in each case.
Well, I understand it's a question of fact, to be sure, but I find it difficult to understand how one decides that question of fact.
Yeah, I mean, I wonder whether it's also got to have a table, or whether you can sit at on the chair with a plate on your lap and eat off the plate. I don't know.
See, the oddity of it is that if it just depends on the presence of a chair, what happens if the chair is removed?
Well, it may be suitable because you could put a chair in.
But the suitability in that sense doesn't form part of the definition of living accommodation. But I mean, I agree. I mean, I think it's difficult. Do you have to have a chair? Do you have to have a chair and a table? How many chairs do you have to have? Do you have to have more than one chair because you have to have people eating together for it to be a living? Or maybe you can have one person.
If one looks at page 47, sorry, paragraph 47 on page 109 of the bundle, it's at F to G. We get a little bit of enlightenment because it seems actually to be a function of size. A kitchenette measuring 6 by 7, containing inter-alia kitchen table, was held to be a living room because it was treated as merely a small kitchen. But on the other hand, an even smaller room, probably no more than an alcove, contained no furniture, in which it was impossible to do anything except cook and wash up. Tenant didn't eat there, was held not to be a living room. So it's really more about size than anything else, it would appear.
It doesn't matter for my case, and I'm not going to we're not going to try and lay down a definition of living accommodation, and whether it's a size or.
But it is relevant to your case, because if you're right on your approach to statutory construction, it makes it unlikely that the kitchen in the property in question is not living space.
Yes.
I mean, there's an inquiry to be carried out, but it looks like it would be unlikely.
Yes.
There's quite a useful passage which Lord Millett cites from Lord Justice Morton just above that as well, which distinguishes between a place where you spend time and a place that you visit for specific purposes, such as a bathroom.
Sorry, which paragraph is that?
It's the quotation
D to F.
in paragraph 47 from D to F.
Okay.
A kitchen is fairly described as a living room. In many households, the kitchen is the principal living room where the occupants spend the greater part of the day. Very often it's the warmest part of the house, and the family tend to congregate there for that reason. On the other hand, both the bathroom and the WC are rooms which are only visited on occasions for a specific purpose. And that would be the same if you only had a right to go and cook somewhere and take your food away. You wouldn't really be said to live in the kitchen.
No.
But as soon as you spend time there, then it's one of the places you live in.
So in relation to paragraph 58, which in my submission is a useful sort of summary of the ratio of the case, we say that the room in which the appellant lives, not a dwelling, is only part of it, because there's also living accommodation in the kitchen. And it's certainly not a separate dwelling, because she shares the use of that kitchen. So on the basis of Euroterm, we can't possibly be looking at the room for the purposes of overcrowding, because it's not a dwelling, it's certainly not a separate dwelling. The key issue is a separate dwelling. And I accept my Lord's point that there's an inquiry to be made there by the respondent, but it hasn't been made, and so on the basis of the information, the facts as found by the reviewer, which is what we're left with, they can't assert that the room is a separate dwelling, because they haven't got the factual basis for that. That's really a sort of ground 2 point.
Is the room suitable for use as a separate dwelling, the bedroom?
No, because it doesn't have a bathroom and it doesn't have a kitchen.
Wouldn't matter whether it had a bathroom.
No, it's mainly whether it has a kitchen. It doesn't have a kitchen.
Your attempt shows you don't have to have a kitchen to be a separate dwelling.
There'd be a dwelling, I think.
Your attempt was a case of a separate dwelling. It didn't have any cooking facilities at all.
Yeah, so if there was no one else in the shared house, because Mr. Collins didn't share with anybody.
But suppose it were let to somebody, the room were let to somebody with 2 small children,
Yes.
with a right to use the bathroom, but no right to use the kitchen. Why would that not be a separate dwelling? Be exactly the same as your attempt.
Yeah, that would be a separate dwelling.
So why is the room not suitable for use as a separate dwelling? Well, this is the problem with suitable for use, which seem to me to be much too wide words if they're given a wide interpretation, because almost anything's suitable for use as a dwelling. If all you need is a room you sleep in, which is what your attempt says, then any room, anywhere, is suitable to be let as a bed-sitting room.
Has to be your home. And so the room is not the home.
Why not?
Because it's only part of the home. Because
What's the rest of it?
The kitchen and the bathroom.
Yes, but if you don't have access to the kitchen, it doesn't matter whether you've got access to a bathroom or not, because we know that doesn't matter for dwelling purposes. Why can't you just say this room could be let to somebody without any cooking facilities? And we know that that is capable of being a dwelling, because that's what your attempt is.
I don't think we know that the absence of a bathroom doesn't make it a dwelling, because your attempt's about a kitchen and the definition of separate dwelling. It'd be difficult to describe a room as your home if it doesn't have a bathroom, in my submission. There's no, so far as I'm aware, there's no authority for the proposition that a room without a bathroom is a dwelling, is somewhere you'd really call your home.
I thought that's what these cases did say. The question of whether you had a separate dwelling depended on your living rooms, and that bathrooms weren't living rooms.
Exactly, it's separate dwelling. They're about separate.
Well, it can't be a separate dwelling unless it's a dwelling.
Yeah.
Okay, well, I don't think, it may not really matter, but I'm just testing how far these words suitable for use as really go.
I understand that.
Yeah. Okay, thank you.
The other case I wanted to look at was CN. And there are 2 bits in CN. First is on page 248. Yeah, 248, where it's paragraph 26, letter H. Court sets out the definition of dwelling from Eurotem. And then the conclusion, the summary of the ratio, is on page 254, paragraph 45. And it's where the Supreme Court followed the Eurotem definition of dwelling as equated with one's home. So that's the case law I want to look at. If I could turn to the Housing Act 88 next, which is the provision which was relied upon successfully below by the respondents to show that the room wasn't a separate dwelling.
Well, you make the point in your skeleton argument. You can't construe an earlier statute by reference to a later one, which seems to me at the moment to be a good point. But then the answer to that is, well, you can also get it out of the 1977 Act.
Exactly.
So maybe we should look at that first.
Yes. The 77 Act, section 22, page 3 of the authorities, is in very similar terms to the 88 Act, section 3.
And the 77 Act was itself a consolidation act, was it not?
I understand that it was a consolidation of previous rent acts.
When the rent acts go back to
1915.
yes, Mortgage and Interest Restriction Acts or something.
They were introduced as a result of the First World War, I think.
Yeah. Stop profiteering.
So we've got section 22. Which bit do we need to look at?
Well, the relevant bits are 22.1, and it's the end of 22.1, and it is the deeming provision. Separate accommodation shall be deemed to be a dwelling house. And we get the same on page 16 in relation to section 3. The separate accommodation should be deemed to be a dwelling house. Also important to look at is subsection 5, which is subsection 8 in the 77 Act, but subsection 5 in the 88 Act, and it's a definition of living accommodation. And the point that we make in relation to this section is it's a deeming provision. So, but for this section, the room wouldn't be a separate dwelling, wouldn't be capable of being an assured tenancy. That this section makes it capable of being held under an assured tenancy. So it rather proves the point that it's not actually a separate dwelling, because if it was, you wouldn't need a deeming provision. Subsection 5 is making this point by saying that ordinarily, of course, you're sharing living accommodation, so that would prevent the tenancy from constituting an assured tenancy. But by operation of this section, we're pretending that it's in fact a separate dwelling. So it rather supports our case that it's not a separate dwelling.
They draw a distinction, these provisions, between where you're sharing with other occupiers and where you're sharing with the landlord. If you're sharing with the landlord, you don't get the protection of the Rent Acts or the Housing Act.
Yes.
Because you're living in the landlord's home.
Yes.
But if you're sharing with other tenants, then you do, because the mere fact you're sharing a kitchen is no reason to deny your statutory protection. That's what this section is doing.
Yes. But it's also saying, ordinarily in that scenario, you wouldn't have statutory protection.
Yes, because it's not a separate dwelling. So, and as your attempt shows, if you share a kitchen, you don't ordinarily have a separate dwelling.
Exactly. So in our submission, the judge was wrong to rely on section 3 to show that it was a separate dwelling, and in fact showed the opposite. If one looks at the 2004 Act on houses of multiple occupation, there's a definition in section 254, which is on page 48 of the authorities, as to what a house in multiple occupation is. And that definition is different from separate dwelling. It's about more than one household sharing basic amenities or living accommodation, if one looks, for example, at subsection 2F. But in our submission, by and large, what is a separate dwelling is likely to be an HMO. So there's likely to be parity between the two.
Why?
Sorry?
Why?
Because if one's sharing basic amenities or living accommodation, then that's an HMO, and the shared house, if it's suitable, I understand it's not the point, but if it's suitable for use as a separate dwelling, then the HMO and what is suitable for use as a separate dwelling are likely to be the same. Not always, I accept, but they're likely to be. And if one looks at the guide to HMOs, which is at the back.
So, forgive me, I'm being very slow about this. Is it your submission that any given house will be, or could be, any HMO can be suitable, either is a separate dwelling or can be suitable as a separate dwelling on two bases? One, by looking at the house, even although it's in multiple occupation, and separately by looking at the individual divisions within the house.
So my submission is that what is suitable for use as a separate dwelling is likely to coincide with an HMO. It's likely to be something where the basic amenities are shared by multiple households.
And each of the multiple households will be suitable for use, or will be a separate dwelling?
Sorry, does my law mean each of the rooms?
Yeah.
No. We're looking at the whole. We're looking at the shared house as a whole. So the shared house as a whole is likely to be an HMO. And it's also likely to be suitable for use as a separate dwelling. Okay. Not necessarily. There's likely to be coincidence between the two. So if one looks at the guidance on HMOs, which is in this bundle at page 396, one can see that although they are two distinct regimes, they're both approaching the issue of overcrowding, but from different directions. So the third paragraph on page 396 says that some HMOs are occupied by the most vulnerable people in society. These people live in properties that are not built for multiple occupation. I'm on page 396, the third paragraph. Not built for multiple occupation, and the risk of overcrowding and fire can be greater than with other types of accommodation. And then jumping down to the fifth paragraph and the sixth paragraph on that page, one can see that one of the purposes behind HMO licensing is to tackle overcrowding. It's the fifth line of the fifth paragraph.
That's because they require a licence,
Exactly.
and the licence can specify how many people you can have in it.
Exactly.
That seems to be a much more focused regime on individual properties than the statutory overcrowding standards.
Yes, I would agree with that. Both regimes doing similar thing, which is to try to stop overcrowding, because overcrowding creates risk to the health and safety of occupiers, in particular fire risk.
What is this publication?
So if my lord looks on page 394, you can see
It's government guidance to
Exactly.
local authorities.
it's guidance to local authorities
On HMOs.
on HMOs. You can see that guidance for local housing authorities from October 2019.
Is there similar guidance from government to local authorities on statutory overcrowding?
Not that we're aware of, but we'll have a look.
Thank you.
Before leaving this ground, I want to deal with 2 points raised by the respondents in their skeleton. The first is that they say that if it's the whole of the shared house, then there will be situations where the room itself might be overcrowded, but if one's obviously looking at the whole of the shared house, it's not caught by the statutory overcrowding provision. And in my submission, that is a possibility. One can see a possibility where the whole of the shared house is overcrowded, but the room isn't, or the room is and the whole of the shared house isn't. But in my submission, that's tail wagging dog, and one has to look at what the definition is of separate dwelling and apply that definition.
Yes.
And the second point which is made, and this is paragraph 65 and 66 of the respondent skeleton, is by reference to the offences. And they're set out in the Act at section 327 and 331. So if we have a look at those, because my understanding is the respondent's argument is that the offences don't really make any sense if they are applied to the whole of the shared house as opposed to the room. And my submission in response to that is, yes, they do. In fact, they make more sense when one applies them to the whole of the shared house as opposed to just the room. So if one starts at the offence caused by the occupier, which is on page 9 of the authorities, section 327. And this is an offence on the part of the occupier who causes or permits to be overcrowded. The dwelling. And what my learned friend says is that if some of the tenants allow adult family members to live with them, at some point the shared house becomes overcrowded, i.e. on the addition of one or more other households. On Miss Rowe's analysis, the occupier whose family caused the whole house to be overcrowded is guilty of an offence. my submission, yes, that is how it works. If an occupier permits or causes overcrowding by permitting someone to enter the dwelling and take up occupation of the dwelling, then they are guilty of an offence. We don't see any issue with that.
So what you're imagining is, if in this house, if one of the other people brings 10 people into their room, they create an offence because they have, on your submission, rendered the house as a whole overcrowded.
Exactly. That seems to make perfect sense to us. And then the other offence is the landlord offence, and that's on page 13. It's section 331, and it's a similar offence. It's the landlord causing or permitting overcrowding of the dwelling. And in my submission, what that's clearly aimed at is a situation where the shared house as a whole becomes overcrowded because of something that the landlord does. And what he does for these purposes is set out in subsection 2. He has to do one of the things in subsection 2. And if he does one of those things, he's liable for the offence. And one offence. If the respondents are right and that each of these rooms is a separate dwelling for these purposes, then the landlord could be liable for multiple criminal offences in relation to the same shared house if more than one of the rooms is overcrowded, because he allows overoccupation, overcrowding of one or more of the rooms. And my submission is not intended to create multiple offences in relation to the same shared house, but one offence in relation to the one shared house.
Going back to your occupier's offence,
Yes.
is it feasible under your interpretation? You could have a house with one room left and someone takes that last room and say there are 2 people in that last room, but that tips the house as a whole over the brink. Can that happen? Because then, what would you say? The person who's come into the house living in an unovercrowded room with 2 people is guilty of an offence in relation to the house as a whole?
So I don't understand the scenario. So there's one empty room in the shared
There's one empty room. The house is full to bursting but not overcrowded on your
Right.
definition. But
Yes.
the addition of 2 more people would make it overcrowded on your definition. The room, the last room, is fine for 2 people on its own. 2 people go in. Does that occupier and occupy, do they then commit an offence because they've caused the house to be overcrowded?
I don't know. I mean, have they caused it?
I don't know. Maybe I'm asking an irrelevant question.
I mean, I don't know. But if they move into the shared house and cause it to be overcrowded, then haven't they committed an offence under section 327?
They have, because they've caused the house to be caused the place to be, the house as a whole to be overcrowded.
Yes. I mean, what my junior is saying is it may be that the occupier may not be guilty of the offence because it may be the landlord who's actually the causation rather than the occupier.
Okay.
Depends if the occupier.
But I think what lies behind my lord's question is you can see that these sections, dating back to 1935, deliberately made it a criminal offence, both for the landlord to let a house to too many people and for the occupier to occupy a house with too many people. Now, one can understand the former in a multiply occupied house because the landlord has control of the whole house. But an occupier only has control of their accommodation. And it does seem bizarre, speaking frankly, that an occupier could be guilty of a criminal offence, not for what they do in their own accommodation, which they can control. They can control how many people from their family, their household, live in that room, but for the impact it has on the number of people who live in the house as a whole, over which they have no control. That is what I think lies behind my Lord's question.
Could well be.
Is there an answer to it?
Well, we say that that's why one looks at the shared house as a whole, because the liability ought to attach to the occupier who brings in the extra person, which pushes you over the overcrowding limit. And there's no question on that scenario of the appellant being guilty of any criminal offence. She hasn't done anything wrong. She's got the right number of people in her room. So she ought not to be liable for any criminal offence. But it's the extra person, it's the occupier who moves in the extra person. I mean, we don't see the problem with that.
But my Lord's example, suppose there are 5 rooms in a house. We know that you can have 10 people in the house. Suppose there are 4 rooms which already have 9 people in them. And then the last room is let to a couple. They've not done anything wrong, but as I understand the question on that analysis, because they're the ones that bring in a number which take it over the 10, they're guilty of an offence. They might not even know how many other people live in the house. Do they have a right to know?
Well, as I said in answer to the previous question, it may be that they haven't caused or permitted. I mean, they haven't permitted themselves. That isn't a situation where someone who's already there, which seems to be the permitting scenario, the person who's already there gets their friend to come and live. And they're not really causing, because it's the landlord who's causing by then letting that room. So that seems to be more applicable where it's the landlord offence rather than an occupier offence.
Okay. Thank you.
I mean, it may be that these criminal provisions don't actually shed much light on what is a separate dwelling for these purposes. But our concern is that if one's looking at the individual rooms, then multiple offences can be committed in relation to the one shared house.
What's wrong with that?
Because in my submission, it's likely that it was intended that there would be one offence committed once the number of people exceeded the overcrowding limit. So the landlord gets prosecuted for one offence of overcrowding, rather than if each room's overcrowded, he gets prosecuted for 5 offences in my Lord's example, if there are 5 rooms and they're each overcrowded. It makes more sense to look at the shared house as a whole when considering these criminal offences.
Well, with the level of fines, you could actually make a plausible argument for the opposite, which is that if you've got a landlord who allows a house to be overcrowded because one room is overcrowded, he is significantly less culpable than the person who crams every single room up to the gunnels.
But wouldn't that be reflected in the amount of the fine rather than in the number of...
Well, I'm suggesting it would be reflected in multiple fines.
But then maybe the point doesn't really help us either way. As I said, there's a definition of dwelling in the Act, and in my submission the question is whether or not the house as a whole fulfills that definition, and one doesn't really get to that answer by looking at the offences. My Lord's made very good points, and the offences can cut both ways. My initial view was really they're intended to be one offence per shared house, but I can see my Lord's point. Maybe there ought to be multiple offences.
Can I go back to 331, which is the landlord offence? When you just read this, without the extended wording of a definition of dwelling in mind, just read it as plain English. It all seems to be directed at a case where a landlord lets a dwelling to an occupier. Because if you look at the circumstances in subsection 2, it talks about a person effecting the letting, and it talks about making inquiries of the proposed occupier as to the number, age and sex of the persons who will be allowed to sleep in the dwelling. And in C it talks about taking possession of the dwelling, legal proceedings if necessary. That all makes sense if you're letting a house to an occupier. You ask the occupier how many people are going to sleep here, and if the occupier brings too many people in, they're guilty of an offence, and you can get possession. But it doesn't really fit with the idea of a landlord letting a room in a house in multiple occupation, because the occupier is not going to know who's going to sleep in the whole house. They're only going to know who's going to sleep in their room. It doesn't make sense to talk about taking possession of the dwelling, because the landlord hasn't let the dwelling. He's let rooms in the dwelling. It all seems to be drafted on the assumption what's going on is the landlord is letting a dwelling to an occupier. In your case, that's not what's happening at all.
What he's doing is he's letting a room, but with shared facilities. But he's not just letting that room. He's saying this is your bedroom, and you're going to share the kitchen and the bathroom. I mean, they could have used a different definition or a different word in 331. They could have used room, because we have the use of the word room in 325, 326. But they haven't used the word room. They've used the word dwelling, dwelling being defined as a separate dwelling.
Okay, thank you.
But that's ground one. Ground two is that the respondents haven't properly decided the issue of overcrowding in this case. And if one turns back to sections 325, 326, and they're in this authority bundle at pages 6 and 7. One can see the sort of information which the respondent would have to make their decision on the basis of. So having regard to the space standard on page 7, in my submission, if you're going to make a decision on overcrowding by reference to the space standard, which was purportedly what happened in this case, looking at the review decision that we looked at right at the start, the respondent would have to know how many rooms there were in the shared house. For the purposes of table 2, they would have to know the size of those rooms.
Forgive me for interrupting again. Can you, if you lose on ground 1, can you win on ground 2?
Yes.
How?
I don't know if I can assist, my lord. I'm sorry to interject. Insofar as it's said that the local authority failed, if it is right that the separate dwelling for the purposes of the overcrowding rules was the whole of the house in which Miss Rowe's accommodation was situated, the local authority did not carry out the investigations that would have been necessary.
Yeah,
so paragraph 27 of my learned friend Skeleton argument is completely and utterly unnecessary. He goes on to paragraph 20.
If he wins on 1, he's going to win on 2. My question was different. If he loses,
no, I understand that. The alternative is, it's said that in paragraph 28 of the appellant skeleton argument, that there was some other way in which overcrowding applied outside of the statutory definitions, as I understand it. So I'm willing, my learned friend doesn't need to make these submissions about the local authority having failed to carry out the inquiries that it would have had to carry out in order, because we accept that he didn't.
Yes, well that's why I didn't ask him the question, if you win on ground 1, do you win on ground 2? Because it seemed to be clear that if he wins on ground 1, he wins on ground
Absolutely.
2. But my question was, if he loses on ground 1,
Yes.
can he win on ground 2? And I'm at the moment I'm still in a slight fog as to how he wins on ground 2 if he loses on ground 1.
My lord, yes. Sorry.
I'd like to know.
Yes.
Or like, I'd put it a different way, I'd like to understand.
Yep. So if we're wrong about ground 1 and one measures overcrowding by reference only to the room, in my submission it is still nevertheless material as to whether the whole of the shared house was overcrowded, even if it's not statutorily overcrowded. And that was really the complaint in this case. The appellant was complaining that there were too many people in the house as a whole, and that her children didn't like being there, and they were treated rather badly by the other members of the house. So if one just parks statutory overcrowding...
So this is a submission that 324 to 326 is not exhaustive.
But the purpose is, yeah, it impacts onto ground 3 as well. But the question in this case was she homeless in this property? Was it reasonable?
Was it reasonable for her to continue to occupy?
And that is not confined to a consideration of statutory overcrowding.
I'm sorry, my lords, I know I'll get it going. I really do apologise. My learned friend has just said that the appellant's complaint was that the premises were overcrowded. I would like him to take me to where that is actually put by her or her representatives, because I haven't been able to find it. Or that she was complaining about the density of occupation out with overcrowding.
So, I mean, I'll deal with
Okay,
this point.
but I think I do understand that effectively what you're saying is that the statutory provisions as to overcrowding are not exhaustive of the question of overcrowding for the purposes of reasonable to continue to occupy.
Exactly.
Okay, I now understand.
One doesn't even have to put overcrowding. They're not exhaustive as to the issue of whether it's reasonable to continue to occupy.
No.
There was also a second issue about whether it was an HMO and whether it was licensed, and that, in my submission, is also relevant to the issue of whether the accommodation was reasonable to continue to occupy.
That's ground 3.
Yes, but it's also ground 2. So if one looks at our skeleton, I'm looking at our affected skeleton, paragraph 27. So the point I've just made is 27A and B. C and D, I accept, are relevant to statutory overcrowding purposes of the space standard. E goes further and F goes further. And at paragraph 28, we say that even if it was not statutorily overcrowded, the respondent was required to consider all the rooms within the HMO which were occupied by the appellant and their family, even if, contrary to ground 1, they were outside the scope of dwelling for the purposes of the overcrowding provision.
When you say all the rooms within the HMO which were occupied by the appellant and her family, that's her bedroom. She doesn't really occupy the kitchen, but do you mean the kitchen as well?
I mean the kitchen and the bathroom.
Right.
I'm not saying living accommodation. I'm saying the rooms that she uses.
The room she uses.
I understand that the bathrooms are occupied for less time than...
Bedroom, bathroom and kitchen.
Exactly.
I mean, her complaint was that one of the other tenants didn't like her children running around the kitchen.
Yeah, exactly. Yeah. And can we look at that? So if one looks at the supplemental bundle, page 3. Near the top hole punch, the fourth thing is reason for contact. Your reason for contacting us, you're overcrowded in your current home. And then on page 19, their case notes. And there's a case note for 8th of March. And it explains that she's got a 7 and a 4-year-old son, rents room and shared accommodation, shares kitchen and bathroom with 4 people.
I'm sorry, where are we looking?
On page 19, case note for the 8th of
Thank you.
March.
Yes.
And then my Lord's point, on the 25th of March, near the bottom, I asked if there was any risk in the property of the area, and she responded she doesn't feel comfortable with one of the tenants living there because he reported to the landlord that her children keep running around, going in the kitchen. Client advised that she feels safe but not comfortable.
And is that said to render it unreasonable for her to continue to occupy?
That's one of the factors which we say is relevant. And then my own friend with his skeleton included a copy of a letter of representations that the solicitors made in May 2021 before the review. And that contains the point which I think my Lord's already seen. The client advises the children are nervous.
Sorry, where do we find that?
Well, I think it's appended to my learned friend's skeleton or affected skeleton.
Unfortunately, I don't think it is in mine.
No, that's not in mine.
Or it could have been added as a tab 14 to the supplementary index. It was sent in to be added to the back of the supplementary bundle.
No.
Found its way there.
Unfortunately not.
Have you got copies?
Right, so apparently we only have one copy at the moment. So what are you referring to?
The second page of that letter of May 2021, it's the third bullet point. And then
Well, am I looking at the right document? Because I'm looking at a letter from Lawstop dated the 10th of May.
That's correct. So on page 2 of that, there are 3 bullet points, and it's the third bullet point that's relevant, and then the last paragraph on that page. Going over to the next page.
Thank you.
Yeah, so that's really expanding on the point made in the case notes.
Exactly.
Can you send that across to Chris? Thank you.
Thank you.
Can we keep these copies?
I wouldn't.
So that's ground 2, and that's why ground 2 can survive even if my law's related. And that takes me then to ground 3. Ground 3 is about the relationship between reasonable to continue to occupy and suitability.
And am I right in understanding that really you put ground 3 two ways as well? Firstly, you say if it's not suitable, in particular because you fail in one of the binary conditions in Article 3 of the order, then ipso facto it's not reasonable for her to continue to occupy it. And in the alternative, if it's not automatic, you say nevertheless it's something that ought to be taken into account.
Yes, well, to put that second point another way, the way we actually say is it's just because a factor is relevant to suitability, it shouldn't be excluded for the purposes of considering whether it's reasonable to continue to occupy.
Yeah.
Does this go back to your submission under ground 2 that the reasonable to continue to occupy is not constrained either by the statutory provisions or it's a generalised requirement which needs to be assessed in the round,
Exactly.
in taking account of all relevant circumstances?
Yes.
Thank you.
So it's for these purposes that I handed up Chapter 6 this morning with the additional authorities. Chapter 6 of the Code.
Yeah.
There's a definition in Chapter 6 of reasonable to continue to occupy. It appears in 2 places. And I go firstly to the very last paragraph of Chapter 6. It's paragraph 6.40.
6.40.
Yeah, well, that's motherhood and apple pie, isn't it? Take into account all relevant factors. Well, of course, how would they do anything else?
And that reflects what's also said at 6.23. Basically the same thing.
This is a code, is this statutory guidance from the government?
Yes, exactly. So under section 182 of the Housing Act 96, local housing authorities have a duty to take into account the code when exercising their homelessness functions under Part 7 of the 96 Act.
And it's provided by the government. Yeah.
Yeah.
Can I just check? The authorities bundle doesn't include 182.
No, it doesn't.
That's okay. Just so I know.
We can get copies of that.
We can.
So the reason why this ground has come to the fore is what the judge says in his judgment at page 60 of the core bundle. It's paragraph 92.
Well, he's right at one literal level, isn't he?
Yeah, he is.
That the requirements and standards are specifically framed by reference to suitability.
Yeah. But he's not applying that literal standard because he then excludes them from consideration. It's that last sentence. My submission, what he's saying there is because they're relevant to suitability, they're not relevant to reasonable to continue to occupy. And indeed, he doesn't take them into account. And the respondent...
Where does he say because?
No, he doesn't say because.
All he says is they're not under a duty to make these inquiries when considering reasonableness.
Yes. So he excuses them from considering these matters because he says they relate to suitability. Which on a literal level, yes, they do relate to suitability, but that doesn't exclude them, in my submission, for also being relevant to reasonableness. Because reasonableness is an all-encompassing, it's not an exclusion, doesn't exclude certain factors. Subject to a relevancy requirement. Whether it was an HMO, whether it was licensed, these are all issues which were relevant in this case.
Well, it is now accepted by the council that given that it is now known that it was an unlicensed HMO, that is something that should have been inquired into, and for that reason the council is going to retake the review decision. So in that limited respect, ground 3 is pushing at an open door. But do you go any further than that with respect to ground 3?
Well,
I appreciate the first way you put it does go further, because if you're right that failing suitability on one of the binary grounds in Article 3 means that you therefore automatically fail reasonableness, that goes way further than the council accepts. But I'm now thinking about the alternative way you put it, because my question is, if we're against you on your primary way, which of course you haven't yet developed, so we'll wait to hear what you have to say about it.
Yes.
But if we end up being against you on the primary way you put it, and so therefore it's just a question of factors that are to be taken into account when assessing reasonableness, where do you get to?
I don't need the first bit. I only need the second bit, and my lord's right that I've been shown to be right on that by the fact that the respondents accept that that's something that's relevant to reasonableness.
Yes, but is there anything more that you say they should be taking into account on reasonableness that they haven't conceded?
Yes. So apart from just the licensing issue, it's back to the points I raised at the in relation to ground 2, which is the overcrowding.
Right. So it's not the mere fact that it's unlicensed, which is accepted something that should be taken into account. It's the fact that it's unlicensed and you say overcrowded, even if not within the statutory limits.
Okay. Can I test this? I thought your submission was that the suitability criteria, which is a statutory list, were always relevant, all of them, to reasonableness. Is that your submission or not?
Yes, it is, but obviously it depends on the facts of each case as to what bits of suitability are relevant.
Because one of the things you mentioned in your skeleton, which is a fact in this case, is there was no written agreement. We know that's one of the boxes you have to tick if you're going to offer new accommodation as being suitable. Is it relevant whether it's reasonable to continue to occupy the accommodation?
I'm not going to push that point because...
But it tests the point, because that's why I said my understanding was that everything on the suitability list is always relevant to reasonableness. And this point is an example of something which doesn't seem to me to be obviously relevant to reasonableness, reasonable to occupy.
Yeah, I see two things in relation to that. It's relevant. It may not be determinative. It may not carry much weight.
Right.
But I accept the point that my learned friend says in his skeleton, that the playing field is really determined by what the applicant says in relation to the application and what's said by the representatives. And I accept what my learned friend says, that the absence of a written tenancy agreement wasn't something which was relied upon in relation to the review. So I don't push that as being a particularly important factor. What the playing field was here is, this is overcrowded, this is a shared house. Now those issues are relevant to suitability, but they were also very relevant here to reasonableness, because they were the basis upon which the application was made. So they couldn't be dismissed simply as being relevant only to suitability.
Suppose an applicant did raise as their sole ground that my accommodation is otherwise fine, but the landlord won't give me a written contract. Would that make the property unreasonable for her to continue to occupy?
No, I'm not saying that a factor like that is necessarily determinative.
But I thought you were saying that the list of suitability criteria were always, if a property wasn't suitable, it couldn't be reasonable to continue to occupy it.
Yes.
But that means if a property which is otherwise ideal doesn't have a written contract, then it's not reasonable to continue to occupy it, which seems an extreme submission.
I accept that, and I'm going to develop this submission by reference to the case law.
Yeah. Okay. Thank you.
Can I look firstly at the Act and section 175 and 206 just to see the relationship between reasonableness and suitability? So section 175 appears in the authorities bundle at page 18. And we're looking at section 175 subsection 3. So the reasonableness test comes from this subsection. So a person's treated as not having accommodation, i.e. they're treated as being homeless, if the accommodation that they do have is not reasonable for them to continue to occupy. And then the suitability requirement comes from section 206. And that's in the bundle at page 42. And the suitability test is applied to accommodation used to discharge housing functions. You can see that from section 206, subsection 1.
So I take it, therefore, you accept that these are different words used in different contexts.
Yes. So reasonableness is judging whether someone's homeless in relation to their application, and then suitability is really at the other end of the scale. So you've accepted that they're homeless, and you're putting them in some sort of accommodation because you accept that you owe them a duty, and the accommodation that you put them in or you find for them has got to be suitable.
So that's clear and realistic. But that being so, it seems a little hard to understand how lack of suitability ipso facto could mean lack of reasonableness.
Right, I'm going to develop this submission when I look at Ali and El Kundi. I'm getting there.
Right, okay. I should let you continue.
Yeah.
Sorry.
So just before I leave these sections, if one looks at page 29, one gets section 193, just so I can illustrate the point about the procedure. So on page 29, section 193, subsection 2.
Give me a second.
Subsection 2 sets out the duty. It's the full housing duty. Secure accommodations available for occupation. We know from 206 that's got to be suitable accommodation. And that only arises where subsection 1 applies. And in particular, if we look here at 1A Roman 1, the authority have got to be satisfied that the applicant's homeless. So they're satisfied as to 175 that they're homeless, and then that leads to the acceptance of the duty, the provision of accommodation, which has to be suitable.
And forgive my ignorance, but there are various levels of duty depending upon the findings.
Yes.
And the appellant is accepted to be a person with priority need who's not homeless intentionally.
Yes.
If she were homeless but intentionally homeless, then different provisions would apply. But the 206 provision is specific to how they have to discharge their functions if there's a duty to a person who's priority need and not homeless.
No, section 206 applies generally to the discharge of functions.
Generally. So anything to do with the provision of accommodation
Exactly.
has to be suitable.
Exactly.
Thank you.
If one looks, for example, on page 24, which is section 188, which is what's often called the interim duty. So this is when an applicant makes an application under subsection 1. If the authority have reason to believe an applicant may be homeless, then they shall secure accommodation. So in that situation, again, it has to be suitable accommodation, but they haven't accepted the full duty.
Thank you.
Where do we find the definition of priority need?
Section 189.
So if you've got dependent children residing with you, you're in priority need.
Exactly.
Thank you.
That's page 27. I want to look at 4 cases: Holt, Ali, Al-Kundi and Timor. So Holt I don't necessarily, I think, need to take the court to, but Holt is a case about what reasonableness means in the context of housing law possession claims, and again it just sets out a similar definition if you take into account everything that's relevant. But the relevant paragraphs are 17 and 18 on page 185 of the authority bundle. And then the next case is Ali, which is a House of Lords case about the relationship between reasonableness and suitability. And that's been considered recently in Al-Kundi, which we'll look at next. But Ali is in the authorities at tab 16. I want to start at page 164. That's paragraph 36. So in paragraph 36, Baroness Hale identifies one of the key differences between reasonableness and suitability, which is that when one assesses reasonableness, one's asking whether the accommodation that the person's in is reasonable for them to continue to occupy into the future. And the ratio of this case, in my submission, is really contained in paragraphs 46 and 47, which are on page 167. And if I could just invite my Lord just to read those 2 paragraphs, so page 167, paragraphs 46 and 47.
paragraph 46, is it being assumed that the accommodation that's been provided has been provided by the authority? Or is it a more general?
It's more general because in this case there are a mix of situations where some of the applicants remained in the accommodation where they were found to be homeless and others were put in temporary accommodation by the council.
Thank you.
And then the last paragraph I'd like my lawyers to look at is paragraph 66 on page 172. So in my submission, the ratio in this case is that the test to be applied for reasonable to continue to occupy requires a relatively high standard, i.e. it's quite easy for an applicant to show that they're homeless. It's quite easy for them to show that it's not reasonable for them to continue to occupy their accommodation when one looks indefinitely into the future. But that it's a lower standard in relation to suitability, which enables a local housing authority to accept that someone's homeless because it's not reasonable for them to remain in their accommodation. But nevertheless, that accommodation or accommodation that the authority puts them in can be suitable because it's only intended for a limited period of time. So one has a scenario of person's homeless under 1753 because it's not reasonable for them to continue to occupy that accommodation for a long period of time indefinitely. But they can nevertheless remain in that accommodation because it's suitable for them. So suitability test satisfied.
Where does it say that? I thought it was simply saying that although property might be unsuitable for the long term, it may be reasonable for the person to continue in the shorter term.
Yes.
And that's what it says in 47.
But what it says there at 46 is that the authority can decide that they're homeless for the purpose of 1753 because it's not reasonable for them to continue to occupy indefinitely or for as long as he will have to do so until the authority take action. So it's reasonable for them to continue to occupy for a short period of time, but that's not the test. The test is whether they can stay there for a longer indefinite period of time. And they can't, and so they're homeless. But nevertheless, they can remain there for a shorter period of time, and therefore it's suitable for them. So they satisfy.
It doesn't say the last bit. But forgive me. Where does it say, and therefore it's suitable?
That's at 47, where it says there are degrees of suitability.
No, but immediately before that it says it does not follow that because that point has not yet been reached, the accommodation is suitable. So it may be reasonable, but not suitable if you're looking in long term. Have I missed the point?
Sorry, I'm just trying to find. what in my submission, what they're saying here is you're homeless because it's not reasonable to continue to occupy indefinitely, but the council is entitled to leave you there for a short period of time because it's suitable for you to occupy on a time-limited basis. But there will come a point where it ceases to be suitable because you've been there so long. And that's the bit about what's suitable in the short term may not be suitable in the longer term.
Yeah, I mean, it helps if you include 48, which makes that sense a little clearer.
Yes, I'm grateful, yes. So Birmingham are permitted to find people to be homeless, i.e. 1753 is satisfied, but that the accommodation therein is suitable. Although there will come a point where it's not even suitable, and then they will have to do something. So this case has recently been considered in El Kundi, which is at page 375 is the relevant bit. Paragraph 105. If I could just invite my lordships to...
Sorry, page?
375.
Thank you.
If I could just invite my lords to read paragraph 105, explaining what the ratio was by reference to paragraph 46, which is what we're just looking at.
Can you assist us as to the relevance of this ratio to our present case? Because as we see from both of these authorities, it's all about the time factor.
Yes.
It's all about the fact that accommodation may be, let's focus on suitability for the moment, may be suitable in the short term, but not in the medium term, still less the long term. So one can understand that as a decision, but what's the relevance of it to our case?
Because what these cases are showing is that there's a process. So the person is homeless because it's not reasonable for them to continue to occupy their accommodation indefinitely, so they satisfy the homelessness under 1753. But nevertheless, the accommodation that they're in is suitable because they're only supposed to be there for a limited period of time. But there will come a point where their accommodation becomes unsuitable.
I understand that, but I'm still struggling to understand the relevance of that to our case.
Because in my submission it shows that you can have accommodation that's suitable even if you're homeless there because it's not reasonable for you to continue to occupy. But that at some point the accommodation will become unsuitable. And clearly by the
time... But in the present case we're not concerned with short-term versus medium-term or medium-term versus long-term.
I accept that we're not concerned with suitability at all. It's not a suitability case, it's a reasonableness case because we're concerned with whether the appellant homeless.
Yes, except that you're trying to argue that lack of suitability translates into lack of reasonableness.
Yes, and I'm in my submission, I'm supported in that submission by reference to Ali, because what Ali says is that you can be in accommodation that's suitable even though it's unreasonable for you to continue to occupy, and then there will become a point where it's unsuitable, and at that point obviously it'll be not reasonable.
Does this go any further than the proposition that you were advancing your skeleton argument that they're related concepts?
No, I mean, I say they're related concepts, and if you find that accommodation is unsuitable, it necessarily follows that it's not reasonable for you to continue to occupy that accommodation.
But I think there's an ambiguity in your use of language here, if I may respectfully say so, because I was speaking for myself. I would not express it if you've got a state of housing. I would not express it in terms of it is suitable, but there comes a point when it becomes unsuitable. What you're actually saying is it may be suitable for the short term,
yep.
or it may be reasonable. And same with reasonableness. If you've got a steady state in the accommodation which the person is in at the moment, you may say it is reasonable to expect them to stay there for 3-6 months. It is not reasonable to expect them to stay there for more than that. And if you use that language, you can see how they're related concepts, because there's likely to be a trade-off. There's going to come a point where you switch from saying it's been reasonable to stay there for that long to saying the deficiencies are such that it should now, A, no longer be regarded as reasonable, and you now need to look for suitable, to see what the suitable alternative, or whether the alternative is suitable. I don't like, with respect, your use of the language that there comes a point when it becomes unsuitable, because you're typically talking about steady state positions, and the question is where you draw the line to take someone out of their existing accommodation and put them into some other accommodation. Is that reasonable?
Where I think we disagree is in relation to it can be reasonable to continue to occupy for a period of time, because that's not what the reasonableness test is about, as shown in Ali and in Al-Kundi. So once you don't ask yourself, is it reasonable to continue to occupy for a period of time? You look ahead to, is it reasonable to continue to occupy indefinitely? And if it isn't, that person is homeless, and they will remain homeless, and they cannot become not homeless.
But look at paragraph 46 of Baroness Hale. Another tool is now available, and in our view it is proper for a local authority to decide that it would not be reasonable for a person to continue to occupy the accommodation which is available to him or her, even if it is reasonable for the person to occupy it for a little while longer. If it would not be reasonable.
So what she's saying there is the authority can find that they are homeless, even if it's reasonable for them to continue to occupy for a short period of time, because when you look ahead to the future, it's not reasonable for them to continue to occupy. So therefore, they are homeless. It is not reasonable for them to continue to occupy.
And if I've understood you correctly, your submission is that must be the correct interpretation of what she says because of the structure of the statutory provisions. Namely, you only get into suitability of accommodation once there's a finding of homelessness.
Exactly. And that's what she says.
Because otherwise, if there was no finding of homelessness, suitability of accommodation wouldn't arise.
You don't have a duty to accommodate.
Yeah.
That's what she says at 48. That's what she's saying. You find that they're homeless, and then you provide the accommodation, and that accommodation would be suitable. So you, local authority, can comply with your suitability duty, even though the person's homeless. It seems counterintuitive, but it's because homelessness looks to the future, whereas suitability looks only at short or medium, or sometimes long.
You've several times said that homelessness requires consideration whether it's reasonable to occupy the accommodation indefinitely.
Yes.
It's not a word she uses. She says until the authority can take action at the end of 46, I think.
I took that word from 48. But she says at 37 until the local authority intervene, but I accept she uses various different versions.
Yeah, indefinitely is the word in 48.
She's saying there the local authority can't leave them there indefinitely. That's a different question. The question is, how do you test whether it's reasonable to continue to occupy the accommodation, i.e., are you homeless? And the answer she gives is that's not asking is it reasonable to continue to occupy for one more night. but is it reasonable to continue to occupy for as long as they'll have to do so unless the authority take action? That doesn't seem to me to be saying that you can be homeless unless it's reasonable for you to occupy it indefinitely. I mean, take this case where sooner or later one of the children is going to reach the age of 10. At that point, there'll be too many people in the room. But that's years in advance. That doesn't mean they're homeless today, does it?
Well, going back to my lord's previous point, if my lord looks at paragraph 66, in my submission she is using the word indefinitely when constructing a test of reasonableness.
Okay.
So the last case I want to look at is Timor, which is at tab 19. And if I could start at paragraph 43 on page 204. So my learned friend relies on Timor because he says this is authority for the proposition that you don't have to carry out a suitability assessment when assessing reasonableness. And I accept that proposition and I don't argue that. And one can see that from paragraph 43. The complaint was that Mr. Appellant hadn't carried out a hazard assessment of the room. And the argument of paragraph 50 was that there should have been a suitability assessment in order to determine reasonableness. And at paragraph 45, the court separates the two tests, as I think my lords have understood, into the sort of first stage, are you homeless? Second stage is the accommodation that we provided you because you're homeless. Is that suitable? In my submission, the ratio is at paragraph 56, which is that you don't have to carry out a suitability assessment in order to determine if someone's homeless for the purposes of 175.
Would you have to if lack of suitability automatically meant lack of reasonableness?
No. So the way we put it is that if you have information, because the applicant's told you or because their representatives have told you, that is relevant both to suitability and reasonableness, you don't exclude it just because it's relevant to suitability. You take it into account in relation to reasonableness. And if it's information which shows that the accommodation is unsuitable, then in my submission it's unreasonable for the applicant to continue to occupy. So in this case, what was being put forward was accommodations overcrowded. And if one looks at section 210 of the 96 Act, which is in this bundle, it's page 43. One can see that prima facie issues of overcrowding are suitability questions in subsection 1. But in my submission, that does not exclude them for consideration as reasonableness questions. court looks at page 58, one finds the suitability order from 2003, Article 3.
Sorry, which page?
Page 58.
Thank you.
So this is Article 3 of the 2003 suitability order, and it renders unsuitable accommodation, which is B&B accommodation, automatically makes it unsuitable. If one turns to the previous page, 57, one can understand what's meant by B&B accommodation, which is simply that an applicant with children shares a toilet, washing facilities or cooking facilities, which is this case, in accommodation which isn't owned or managed by the local housing authority. So this is, by virtue of the 2003 order, it's unsuitable accommodation. And that, in my submission, is a factor that isn't to be excluded because it relates to suitability, but is very much to be included when one considers reasonableness to continue to occupy.
Well, can I just lob one little thing in? We've been referred to 3 orders.
Yes.
1996, 2003 and 2012. 2003 and 2012 orders are made under section 210 and they refer only to suitability.
Yep.
The 1996 order refers both to reason, which is not in the bundle, refers both to reasonableness and to suitability and is made, surprisingly enough, under section 177 and section 210, contrary to the respondent's submission that there's no orders under section 177. So, in the structure of these orders, there appears to be a distinction which follows the distinction in the primary legislation between reasonableness and suitability. I'm not suggesting that that kills or even necessarily blunts your point, but it does reinforce the suggestion that they are separate concepts which should be looked at differently.
I accept that, and that's why I went to Ali and so on to show that they are separate concepts they look at differently, but they are related concepts. And suitability is much more prescriptive because although it's much easier to satisfy, it's a lower test. So local authority, it's relatively easy for a local authority to show that the accommodation is suitable. Nevertheless, there is a certain minimum level below which they can't go, and that's why it's prescriptive. So you can't put families in shared facilities for more than 6 weeks. That's a no-no. And we're seeing in relation to the 2012 order that it's quite prescriptive in relation to private sector as well. But that doesn't mean that you don't take account of these factors in relation to reasonableness.
But there's a difference between taking account of and regarding it as ipso facto.
Yeah. I accept.
Your submission is it's one or the other.
No. My primary submission is if it's unsuitable, it must be unreasonable to continue to occupy. Because Ali tells us that, and El-Kundi. Because once you've reached a stage where the accommodation is unsuitable, you must necessarily, it must be not reasonable for you to continue to occupy. But if I'm wrong about that, and it doesn't follow ipso facto, then I say that just because these are suitability issues doesn't mean you exclude them in relation to reasonableness. And I accept that they are suitability issues because there is legislation which is setting out minimum standards in relation to suitability.
Can I just go back and make sure I've understood? I'm sorry to be so slow again. What you said about the playing field. And did I understand you to say that you accept that the playing field of issues to be decided by the authority, either originally or on review, is established by the complaints that the applicant makes?
Not exclusively.
Because they've got a duty to make inquiries.
They've got a duty to make inquiries and they've got to be satisfied as to certain legal tests, and so But generally, the applicant will put forward the facts, but it's for the authority to go away and make legal decisions and to carry out the duty to make inquiries is in section 184, subsection 3, which is in the bundle.
Thank you.
Because an applicant will often not know what they've got.
So take the present case. The applicant put forward information indicating that the property was an HMO. That it is now accepted that the council had a duty, based on that information being provided by the applicant, to look at its own register to see if it was licensed or not, because it had that information. And if it had looked at the register, it would have found that it was unlicensed. That much is accepted.
She also puts forward that she's overcrowded. She doesn't have to say, I'm overcrowded in breach of the room standard or the space standard. She just has to put forward, I'm overcrowded, and then the duty is on the authority to make inquiries about that and to work out whether or not she's overcrowded by reference to the 85 Act.
Yeah, but it's only a duty to make such inquiries as are reasonable for the authority to make.
Exactly.
Thank you.
The other order that's come up is the suitability order from 2012. It's page 64. It's Article 3.
So just help me on this rather basic point, which I haven't quite got my head around yet. Am I right in understanding that the 2003 order and the 2012 order sit side by side? It's not that the 2012 supersedes the 2003.
Correct.
Thank you.
And that's why in my submission, suitability is quite heavily prescribed by these various orders. And Article 3 is looking at private sector accommodation. We can see that from page 65. And it sets out circumstances which the authority have to be satisfied about in order to be able to offer private sector accommodation. And it's relevant in this case because F includes a house of multiple occupation that's not licensed.
Yeah.
So
And that's mandatory in terms of suitability.
for private sector, yeah. So it would be unsuitable as a private sector offer if it was an unlicensed HMO.
Can we just test it again, a bit rather as we did before? If you had a house which was the most pucker HMO that you could possibly imagine, but it wasn't licensed, I can understand the submission that that is a relevant factor to be put into the balance. But you're not submitting that would be determinative that it was not reasonable, are you?
No, we're not submitting that because my learned junior correctly says it's only in relation to the narrow area of private rented sector offers unsuitability, not suitability generally.
But you would submit that it's a relevant,
Yes.
or at least a potentially relevant factor.
Well, but if it is private rented, then you say it's determinative, because your submission just a moment ago was that if you fail on this checklist, then it's unreasonable. So of course it's different if it's not private rented.
Yeah, so we do say that it is determinative in relation to the context in which Article 3 applies, but not otherwise, because Article 3 is narrowly confined to private sector. Those are all submissions on ground 3.
I'm sorry, I haven't understood that last submission. I'm obviously being very slow. I thought your primary point under ground 3 was that if something is not suitable, it can't be reasonable to continue to occupy it. Here is a list in Article 3 of a number of prescriptive things which you have to satisfy in order to be suitable for a private sector rented offer. Are those failure to comply with those ipso facto, do they ipso facto mean, on the facts of the present case, that it's unreasonable for your client to continue to occupy her room?
Can I just turn around to... Well, only Julie's going to answer the question.
Yes.
My lords, can I turn you to the 2012 order?
Page 64.
Yes. I'm grateful. To Article 3.
Yes.
My lords, there are different contexts in which accommodation can be suitable. Suitable accommodation is required for temporary accommodation under Section 188, which is a duty to provide accommodation in cases of apparent priority need, for example. So before a final decision has been made as to whether the full homelessness duty is owed. My lords, the duty to provide suitable accommodation also arises under Section 193, and one of the ways in which that can be discharged is by way of a final offer of private rented sector accommodation. So what we say, my lords, is that suitability can be different depending on the type of accommodation and the way in which the offer is made. So if an offer is made under Section 188, that is not the local authority washing its hands of the applicant, because the decision will be then be made under Section 193. And so this order doesn't necessarily apply to render accommodation unsuitable under all circumstances, but it would apply where there's a final offer of private rented sector accommodation, which would mean that the local authority is in effect making a final offer to bring to an end the assistance that it will offer the...
Well, I mean, you're absolutely right to point out that Article 3, paragraph 1, states in terms that the suitability criteria that are listed apply for the purposes mentioned in paragraph 2, so it's not for all purposes. But as I understand it, what we're concerned with here is, I'm not sure whether it's A or B that is relevant. I assume it's B in paragraph 2. So determining, in accordance with Section 193A or 193C, whether the local housing authority may approve of a final accommodation offer made by a private landlord. So, as you were saying, we're concerned with suitability for private rented sector, and also the same in A. But of course, in the present case, we are concerned with private rented accommodation. So, is it not your client's case, therefore, that if you're failing suitability under Article 3, given that we're talking about private rented accommodation, therefore it's unsuitable?
Well, Your Honour, we accept it might be suitable, for example, my Lord, we accept it might be suitable, for example, in principle, might be suitable, for example, under 188.
Well, because that's not one of the purposes listed, to be sure.
And so
Well,
we accept.
Well, Lord, I'm really sorry to interject, but if you look at paragraph 2, little Roman 2 of the 2012 order, you'll see the purposes are determining whether any accommodation made available for occupation under a tenancy with a private landlord. It was found by the review officer that in this case there was a tenancy with a private landlord because it was an assured tenancy.
I think we understand that.
Sorry, it's just my learned friend as suggesting that there is some disparity between the circumstances in which the accommodation is provided, whether or not the suitability order applies. It wouldn't apply to a licence that was provided in relation to interim accommodation. Where a tenancy is granted.
Mr. Grundy, I'm grateful for your intervention, for drawing that to our attention. But at the moment, all we're trying to find out is what the appellant's case is, because we had understood from reading the skeleton argument, and it appeared to be confirmed by Mr. Van Heegen at earlier stages of his submission, was that on ground 3, the appellant's primary case was that if the accommodation was unsuitable because one of the binary conditions in Article 3, paragraph 1 was not satisfied, therefore it necessarily followed that the accommodation was not reasonable for the appellant to occupy. And in the alternative, it was the appellant's case was that at minimum, that was a relevant consideration to take into account. Now, the question we want to know is that still the appellant's case, or is point 1 abandoned?
Your Honour, we may return to this and reply. For present, my submission is simply that there's a distinction between suitability under different provisions, and we accept that. And the point is that if this was provided, if this accommodation was provided in final discharge of a duty owed to my client under Section 193, then it would be unsuitable. And that's the reason that we say it's unreasonable to continue to occupy, because that's at the point that duty is discharged, the accommodation will be occupied then into the future. It's not a case where it's temporary accommodation provided by the local authority.
All right, well, I think that's clear enough for present purposes. Thank you. Thank you very much. Yes, Mr. Oh, I see it's. In fact, by that clock is slow. I've just realised slightly late in the day. Apologies for that. So we'll resume at 2:05.
My Lord, yes. My Lord, before you rise, I presume you want copies of the additional statutory material you referred to.
Well, I've got copies.
Copies
For my lord, I haven't copied it for my lord.
No.
But,
So don't break your neck. If it's convenient to provide it over the short adjournment, that would be appreciated. But if it's too difficult in an hour, don't worry about it.
My Lord, yes.